Welcome to the California Workplace Harassment Prevention Training. This training is designed to help non supervisory employees understand their rights and responsibilities under California law. At the end of this video, you'll know how to identify harassment, understand your rights, and the appropriate steps to create a safer workplace. The content of this video is for informational purposes only. It is not intended as legal advice. Laws and legal requirements regarding harassment prevention can vary by jurisdiction. So, this means you should verify the specific legal requirements that apply to you, to your state, and consult with a qualified attorney if you have any questions or need specific guidance. And just so you know, liking and subscribing is appreciated. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. Okay, so did you know that more than 60% of people, 60% of employees face harassment at work, never even bother to report it? That's a staggering number considering the millions of workers that exist in the US. And what's even more staggering is even when someone does speak up, they don't see any real change or justice. Well, guys, this creates an additional barrier to harassment prevention. How can you prevent harassment if those people speaking up about it don't see the benefit of speaking up? I understand the fear and isolation that can come from facing harassment. You're looking at fear of not being believed, fear of job security, and the unknown way that coworkers, friends, people who have become like family might respond. I understand it because I've been there too. And today I'm opening up about how to spot these behaviors, the right way to report them, and how we can work together to stop misconduct at work. Because we all deserve a safe and respectful place to work. This training includes real world examples, legal definitions, and interactive features, so stay engaged and be ready to test your knowledge at the end with a quiz. By watching this video and using the interactive resources provided during this training session, you will gain the knowledge you need to effectively identify, prevent, and report misconduct if it happens. This is such a powerful step towards transforming your work environment for the better, and it also shows your commitment to learning these important skills. Harassment, discrimination, and retaliation have no business in our businesses. They are, without question, completely unacceptable. There has been a seismic shift in tolerance levels for harassment. What used to be okay isn't anymore. And if you harass or assault a colleague, an employee, a boss, or a business contact today, your job will be in jeopardy. People feel empowered, which is good, but some will take advantage, which is not good. And that's another reason why it's so important to take these complaints seriously. Behavior that was acceptable just 20 years ago is no longer tolerated. Victims are empowered to speak up, and many no longer feel silenced by shame or fear. What does Me Too mean to you? Please pause the video for a moment and share your thoughts in the comment section. The Me Too movement has empowered victims. Women were once silenced by shame of reporting, but that isn't as successful as it once was. Belief in women's experiences has grown, and the Me Too movement has played a significant role in demonstrating the validity of these shared experiences. Anti-harassment legislation doesn't just apply to employees. An employer may be held liable for harassment by non-employees as well, such as a customer's harassment of an employee if the employer knew or should have known of the harassment, had the power to control the conduct of the non-employee, and failed to take prompt corrective action. Anyone who comes into the workplace or who you associate with due to your work duties can create a hostile work environment. The mail delivery person, the copy machine repair person, a customer, or a client can all impact an employee's ability to do their job. An employer can also be held strictly liable for the acts of its supervisors who engage in harassment. Supervisors and managers can be sued personally for harassment with potential criminal liability for individuals, and the statute of limitations for sexual assault has been extended to 10 years. Good news is, when we all do our part independently, our collective effort result in a much easier, much safer, more respectful, and more equal workplace for all of us. Okay, so let's start by defining what workplace harassment is. Under California law, FEHA, Fair Employment and Housing Act, harassment is unwelcome conduct based on a legally protected characteristic that creates a hostile, intimidating, or offensive work environment or negatively affects employment. A common question that I am often asked about harassment is, what is the standard? How do I know if I've crossed the line? And I like to tell people to use the mom test or the daughter test. Let me explain. Think of a person that you feel protective of, and imagine that person experiencing the conduct that you have heard, witnessed, or been accused of conducting. If it's not appropriate for your mom or your daughter to experience that conduct, then it's not appropriate for the employee. It is the duty of a manager, especially to act if they become aware of harassment. And how you act depends on the circumstances, but it will likely involve stopping the conduct and, if it's severe, reporting it to human resources. Under California law, employees are protected from discrimination and harassment based on specific legally recognized characteristics. In other words, it's illegal to treat employees unfairly or engage in conduct that targets them on the basis of personal traits, such as race, color, national origin, sex, gender identity, gender expression, sexual orientation, pregnancy, childbirth, or related medical conditions, religion or religious beliefs, disability, physical or mental, age, 40 years and older, genetic information, marital status, military or veteran status, ancestry, citizenship, or immigration status. This means that any adverse action or inappropriate behavior directed at employees because of these protected characteristics are illegal. As a result, employers must not only avoid overt discrimination, like firing or demoting someone because of their race, gender, or religion, they have to also avoid more subtle forms of bias, like excluding employees from opportunities or creating a hostile work environment based on these traits. The law is clear. Any action that undermines an employee's rights due to these protected characteristics is unlawful. In other words, if an employee is treated unfairly or subjected to negative behaviors simply because of characteristics such as race, gender, age, or other legally protected traits, the law provides them with specific steps they can take to seek justice. This protection is key to helping ensure that everyone is working in an environment that is respectful and inclusive. And the protections for these personal traits underscores that all employees are entitled to work in an environment where decisions are based solely on merit and performance, those things that they achieve, not on personal characteristics like ethnicity, gender, or religion. Any adverse action, whether it's a reprimand, isolation, or even subtle forms of bias, when it's based on these factors, it's not only unethical, it's also illegal under current employment laws. If you want to know more about subtle signs of workplace harassment, be sure to watch my video, Workplace Retaliation Explained, How Timing Proves It, and the Legal Tests to Know, because it breaks down exactly how retaliation claims work, the crucial role timing plays, and the legal standard that courts use to evaluate evidence. Harassment is any unwelcome behavior based on race, color, religion, sex, national origin, age, disability, or genetic information. There are two types of workplace harassment. The first type is sexual harassment or quid pro quo harassment. This occurs when job benefits like promotions or favorable work assignments are directly linked to an employee's acceptance or rejection of unwelcome behavior. For example, if a supervisor implies that an employee's career advancement depends on the employee's willingness to tolerate inappropriate comments. Hostile work environment is another form of harassment, which involves behavior that is pervasive or severe enough to create an intimidating, abusive, or offensive work atmosphere. It may not involve a specific quid pro quo exchange, still undermines an employee's dignity and that employee's ability to perform their job effectively. Examples of this would include a manager who offers a raise in exchange for a date. Also, a coworker who is repeatedly, more than once, making inappropriate sexual jokes. Also, any physical touching or gestures or comments that are unwanted and unwelcome by the employee who is receiving them. Harassment is not just about opposite sexes. People of the same sex can harass each other based on gender. Anti-harassment legislation applies to everyone, from the CEO to line employees, and harassment in the workplace is prohibited even if the perpetrator is not an employee. Job-related harassment is prohibited even if it occurs away from the worksite. For example, harassment would be prohibited during a business trip or at a client's site. It's also important to understand what harassment is not. For example, asking someone out on a date or twice, making an offensive joke not based on an individual's protected characteristics, or making an isolated sexually offensive joke. These scenarios can generate legal claims that are costly to defend, but they do not meet the standard for actionable harassment under federal law. But a request for a date could become harassment if the speaker refuses to take no for an answer and repeats the behavior, making the behavior pervasive or severe. This is why it's so important to stop the behavior before it repeatedly occurs and qualifies as harassment. Employees should also be mindful that emails, text messages, and social media could become tools for harassment. Managers accepting or soliciting requests to or from subordinates to be friends on social media is problematic because the private information shared on those platforms may impact the relationship at work. Emails and social media posts may be forwarded or misdirected, increasing their reach and potential fallout. It's important to remember that emails continue to exist, even after employees delete them. Employees may perceive their social media activity as off-duty conduct, but if it involves interactions with coworkers and violates an employer's anti-discrimination and harassment policies, it can be treated as a workplace issue. In addition, activity on employer-owned computers, such as visiting inappropriate websites, can be monitored and easily traceable. It's important to consider all of these points before you post on social media or send an email. Check out my video on Twitter's layoff debacle, which unfolded right after Elon Musk purchased the company and rebranded it as X. The video takes a closer look at how systemic harassment ties into gender discrimination and offers a real-life look at workplace harassment. So, what would you do if you overheard a coworker making an inappropriate comment about another employee's appearance?
What do you think would be the best way to handle it? Please pause the video, take a moment to think about it, and then share your response in the comments section. Harassment can also show up in verbal and physical forms. For example, name calling, insults, or offensive jokes to others, not to mention yelling, aggressive behaviors, the types of conduct that would intimidate an employee. Harassment can also be demonstrated through physical intimidation, like blocking someone's movement or gestures that cause discomfort. This type of conduct is illegal and it can have serious consequences on an employee's mental and emotional well being, not to mention the impact that it can have. If
in
you'd
the
like to learn
workplace.
more about harassment prevention and better understand the legal standards required to prove harassment, check out my video. She had 5 pages of evidence, but it wasn't enough. It's a real life case study that clearly shows what's needed and oftentimes what is missing to meet the legal standard for harassment. Visual harassment can be anything that is visible to another worker, like offensive posters, cartoons, drawings that are displayed at work, or the act of sending inappropriate messages, or suggestive emails, or text messages. Retaliation and bullying are another form of harassment, and the behaviors are closely linked together because when an employee is subjected to bullying, it's often triggered by retaliatory actions, which is why these issues are typically linked and addressed together. Retaliation occurs when an employer takes an adverse action or a negative action, really, against an employee for reporting harassment or participating in an investigation. This not only harms the individual employee, but also discourages others from coming forward, ultimately creating a work culture of fear and silence. Examples of retaliation include being demoted or fired after filing a complaint, a demotion, salary reduction, or unfounded and illegitimate disciplinary actions, having work hours cut for speaking up about misconduct, or even termination. Retaliation can also be intentionally covering up retaliatory conduct. It's important to know that the law protects employees from retaliation, and that helps make sure that when employees do have the courage to speak up or to help out in an investigation, that they're not going to be punished for their efforts to promote a safe and respectful work environment. If you want to know more about retaliation at work, check out my video, Workplace Retaliation. It covers the legal case between the University of Texas Southwestern Medical Center versus Nassar and the retaliation efforts that were taken by the employer in that case and what the court decided as a result of the employer's actions. California law mandates that employers not only have a harassment complaint process in place, but also ensure that it's transparent, it's accessible, and well documented for every employee. And this requirement means that the complaint process details step-by-step instructions on how employees can report harassment, including who to contact and what information is needed. This requirement means that the complaint process must include confidentiality and safety measures that protect the identity of those reporting the harassment by maintaining confidentiality throughout the complaint process. The complaint process also has to include protection against retaliation. It has to clearly state that retaliation against anyone who reports harassment is strictly prohibited and outline how such retaliation will be addressed. This requirement means that the complaint process must include regular communication and training. Employers are required to actively inform and train employees on the complaint process, making sure that everyone understands their rights and the procedures available for filing a complaint. The complaint process must also include a timely response. It has to include guidelines on how promptly investigations will begin and how outcomes will be communicated to those involved. Ultimately, this legal requirement is designed to foster a respectful, safe, and inclusive work environment
that encourages employees to come forward with concerns without fear and ensuring that any issues are handled timely. So, what should you do if you experience or witness harassment at work? Let's talk about the steps you should take. The first step is to document what has happened. Write down the date, time, and location, what happened, how it made you feel, and save any relevant email, messages, or evidence. If you're comfortable, consider confronting the harasser. Describe the behavior that bothers you, why it's a problem, how you feel, and how it affects your environment. Tell the harasser that the harassing conduct must stop and explain how you would prefer the situation be handled. Inform the harasser that if the harassing behavior continues, you will complain to management. The next step is to report what you have seen or experienced to human resources or management. Managers and supervisors are held to a higher standard than non supervisory employees when it comes to harassment prevention. They are required to take immediate action if they witness or become aware of harassment. If you are a coworker who learns about harassment, listen, and if the harassed person is comfortable, suggest that he or she confront the alleged harasser. Offer to practice the confrontation and suggest supportive feedback. Encourage the person to report the harassment to the person or department that the harassment policy designates to receive these types of complaints. And you should also report it yourself. If you are the alleged harasser, that is, you are the person who's being confronted about your own behavior, the first thing to do is to listen. Try not to be defensive. Keep an open mind, even if you disagree. Stop the offending behavior if possible. Express your willingness to address the situation, and if you cannot stop the behavior, tell your supervisor, speak with management or human resources. It's important to remember that if you are the alleged harasser, you need to maintain a normal working relationship with the person who is accusing you or confronting you about harassment. Don't retaliate against the employee for his complaint or her concerns. Cooperate with them. Tell them the truth in the investigation and don't spread rumors about the situation. So always remember the mom test or the daughter test. It is such a good rule of thumb to live by in the workplace. If the conduct is not appropriate for your mom or your daughter to experience, it's not likely that it's appropriate for a coworker. You also want to be sure and follow your employer's internal reporting procedures. If your reporting internally doesn't resolve the issue, external agencies can also help. One external agency that supports employees in claims of harassment is the California Civil Rights Department. You can file a formal complaint by going to the website shown on the screen, and employees have 3 years to file a harassment claim with the California Civil Rights Department. It is illegal for an employer to retaliate against you for filing a complaint. If you face retaliation, you have rights and legal protections. If you are interested in a real life case about workplace harassment in California, check out my video, Workplace Mobbing and Retaliation in Medicine. In that case, the employee followed the internal procedures for filing a harassment complaint, but when she didn't get a resolution, she took the next step. She filed a complaint with the Civil Rights Civil Department in California, and in the end, she got justice. It's a powerful example of how knowing your rights and taking action matters. This training emphasizes the importance of both preventing harassment and maintaining a safe workplace. Prevention is truly essential for a harassment-free environment. If you are an employee, speak up if you witness inappropriate behavior and support your coworkers who experience harassment. And take action early to stop harassment from spreading. If you are an employer, enforce clear anti-harassment policies, provide regular training, and encourage reporting.
take all complaints seriously and investigate them promptly. For a real-life case about how workplace harassment investigations can go wrong, check out my video, Workplace Investigations Gone Wrong: What Happens When Employers Mess Up. It covers the story of a director in an Oklahoma school district who filed a harassment complaint against her employer. When workplace investigations aren't handled properly, it can have serious consequences, not just for employees, but for employers too. We've covered a lot of material today. Let's review what we've learned. Workplace harassment, we talked about what it is and how it impacts employees. We also talked about what it is not. We looked at different types of harassment, including sexual harassment, bullying, and retaliation, which lead to a hostile work environment. We discussed that harassment is not just about opposite sexes. People of the same sex can harass each other based on gender. We also discussed how anti-harassment policies apply to third-party vendors and customers. We talked about how to report misconduct and protect your rights, and how to help create a safe and respectful workplace. And don't forget about the additional resources, which include a frequently asked questions document or FAQ on sexual harassment in California, a sample complaint procedure, and a sample anti-harassment policy for California. Now that we've covered key aspects of workplace harassment prevention, it's time to test your knowledge. Click the link in the description to take the official quiz. Let's review what we've learned today. We talked about what workplace harassment is and how it impacts employees. We talked about different types of harassment, including sexual harassment, bullying, and retaliation. We also discussed how to create a safe and respectful workplace. By completing this training, you're helping to build a workplace where everyone feels valued and respected. Take the official quiz now and subscribe to the HR Insider for more workplace training videos. Like, comment, and share to help others stay informed. If you're looking for general workplace harassment prevention training that meets federal compliance requirements for all states, check out my video, Workplace Harassment Prevention Training: Stop Bullying, Retaliation, and Discrimination. This training covers important topics and reviews key aspects of harassment prevention. Thanks for watching. I'll see you in the next video.